what is tomorrow but today. So, I realize the last video said tomorrow. It's actually only been like 5 minutes, but we'll just pretend it's tomorrow, okay? So, the hierarchy of race is going to lead us into our Gilded Age and our future of America. And with social Darwinism and all of this concept, we get the legalization of segregation. Now, remember, after the Civil War, we've got all of these amendments that say you can't do certain things, right? You cannot prevent people from having the right to vote just because of their skin color. You can't prevent them from having citizenship because they were born enslaved. But we can prevent them from participating in society. All we have to do is find a loophole, right? And if there's one thing unrepressed people who very much play the victim are able to do, it's find loopholes. So we are going to look at segregation laws and the ruling that will effectively destroy all of the benefits of Reconstruction for good for the next 50, 60, 70 years. So post-Reconstruction in the South, once we get rid of the black codes, we've got states that are passing Jim Crow laws. Jim Crow is a minstrel character. He is a white person in blackface who goes on stage and acts the way a white person would interpret a black person to act. You can look it up if you want. I'm sure there's plenty of examples of it. He's not a real person, but the laws are named after this character. And these laws are mostly based on all of the old black codes from before the Civil War. And their goal is to prevent blacks and whites from interacting and sharing public spaces. And if you remember that anti-miscegenation, like, we don't want blacks and whites mixing because that's a horror to the human race, right? So Louisiana is the home of these laws in the situation that we're about to look at. And so in 1890, they passed a law that required racial segregation on railroad travel within the state. And this took the place of a former Reconstruction era law from 1868 that said that all persons are allowed to enjoy equal rights and privileges upon any conveyance of public character and all places of business or public resort without discrimination or discrimination on account of race or color. So in 1890, the state of Louisiana decides they're going to pass a new law over this, which essentially says that they cannot enjoy equal privileges in the same space. They can have equal privileges, but they have to be separated. And once the law is passed, the black citizens of New Orleans present a written petition to the legislator that protests the law, and then form a committee to test the new laws to find out how constitutional this actually is. This is like a prelude to Rosa Parks. This is almost exactly how the Rosa Parks boycott in Birmingham happens later on. The committee chooses a person that is going to break the law, and they are going to use that to take the case to the Supreme Court. It is planned. It is not a spur of the moment activity. So this is the first time that we are going to challenge the constitutionality of these Jim Crow laws further than the state, hopefully, although they were actually just hoping the state would rule it as unconstitutional. So the plan here is that they're going to find a black man who's nearly white, those are their words, a nearly white Negro. They're going to have him ride in the train cars to use this as a case that forcing this man out of the train car to go sit in a different one is an invasion of rights. And they've decided that they needed to find a person of fairly tolerable complexion because they didn't want somebody who looked too black, because they figured that if a person looked too black, that they wouldn't get the results they were hoping to get. So they are well aware of the concept of whiteness, and so they're finding somebody who is mostly white. And so they settle upon a man named Homer Plessy. And according to his records, he is described as 7/8 white. And so in 1892, in June, Homer Plessy buys a ticket to a first-class train in Louisiana, and he sits in the white section of the train heading from New Orleans to Covington, Louisiana. And of course, the conductor comes along and tells him to move to the colored section. And Homer Plessy refuses to move to the colored section, and so he's removed from the train by a detective. Again, this is what they want, right? This is part of their plan. He's removed and he's jailed. And the judge in charge of the lower courts is John H. Ferguson. And so this is all going to plan, because if he's not removed and he's not jailed, you can't fight the law and find out if it's constitutional or not. So it's all going to plan. He's removed, he's jailed, and they sue the state of Louisiana for violating Plessy's rights. And so the case becomes known as Plessy versus Ferguson for Homer Plessy, the rider, and John H. Ferguson, the lower court judge. And it is heard by the Louisiana Supreme Court, and no surprise, they upheld that the separate car clause is fine. Its existence, according to the law, is that the existence of this is a natural, legal, and customary difference between the whites and blacks races in the state, makes their separation as passengers in a public conveyance the subject of sound regulation to secure order, promote comfort, preserve the peace, and maintain the rights both of carriers and passengers. So they're leaning on that concept of social Darwinism, that races have to be divided. It is the natural order of things. And so once it's heard by Louisiana, it is elevated to the Supreme Court of the United States. It's heard in 1895 and it is decided in 1896. And what is decided in 1896 is an upholding of the Louisiana ruling. All but one justice upholds the idea that separate but equal facilities are legal and reasonable. So, if you look at the majority opinion, they're saying every exercise of the state police power must be reasonable and extend only to such laws as are enacted in good faith or for the promotion of the public good. And separate but equal is in good faith and for the promotion of the public good. And there's one dissenting justice, John Harlan, who says this is not okay. And he questions the logic, asking if the state could separate black people from white people in this way, could the state not also separate people along a variety of other characteristics, hair color, religion, national origin? And his famous dissenting quote, he says, "We boast of the freedom enjoyed by our people above all other peoples, but it is difficult to reconcile that boast with the state of the law, which practically puts the brand of servitude and degradation upon a large class of our fellow citizens. The thin disguise of equal accommodations will not mislead anyone, nor atone for the wrong this day done." So Justice Harlan has this power of foresight that a lot of people seem to lack, and he sees that by declaring a law that it's okay to separate people, that it is going to be a problem, things will not be equal, and that we are doing something that is going to be very hard to undo. And for the next 100 or so years, a little bit less than 100, but he's right. And so Plessy versus Ferguson gives us this ruling that it is okay to separate people based on their race, which gives us the concept of what is called de jure segregation, which means by the law, which it puts it into law that African Americans and people of color are not allowed into public spaces. Loopholes, right? So now we have the Supreme Court saying it's okay to have separate but equal. So we're going to separate the facilities, and we're going to deny African Americans access to a lot of places: state colleges, voting booths, jury boxes, playgrounds, parks, libraries, neighborhoods, public transportation. Anything you can think of is going to be segregated, mostly in the South. There is segregation in the northern states, but it's not on the books. It's not de jure segregation, it's de facto segregation, which means it's happening by practice. It's technically not a law, but it is happening through practice. And this is where you get those for whites only, for coloreds only sides, and separate but equal is going to be the defense for these signs that it's okay because the Supreme Court said it was okay. And as Justice Harlan was accurately predicting, none of these accommodations are equal, but for the next 50 to 100 years, this is how it is until we get to that next step with Rosa Parks and Martin Luther King and all of those future civil rights activists.